Good morning. Welcome to today's Federalist Society virtual event. Today is Friday, November 8th, and we are here to talk about the recent decision by the University of Pennsylvania Law School to discipline Professor Amy Wax for alleged violations of professional norms, and also to consider how this case fits within recent controversies and questions involving academic freedom and freedom of thought in higher education. I'm Melita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. I want to flag just a couple of upcoming events. This coming Monday at 11, we will be hosting a webinar on working as a conservative on the other side of the V. Of course, next Thursday through Saturday, I hope to see many of you at our National Lawyers Convention. And I do want to flag in particular the Freedom of Thought breakout panel next Friday at noon on preparing for courageous and effective public service. Now, turning back to today's program, I am delighted to have Judge Jim Ho with us to moderate our discussion for today. Judge Ho is well known to many of us within the Federalist Society and especially within the Freedom of Thought audience. He serves on the Fifth Circuit Court of Appeals, previously served as the Texas Solicitor General, clerked for Jerry Smith and Justice Thomas, and many other biographical details on his bio page at the Federalist Society website. As always, please note that all expressions of opinion offered today are those of the experts on today's program. We encourage our audience to submit questions for our panelists through the Q&A feature at the bottom of your screen. Judge Ho will turn to that towards the end of the program. He will direct that conversation, but if you would like Judge Ho to ask a question, please submit your question in the Q&A. Thanks very much for being with us today, Judge. The floor is yours.
Thank you, good morning. It's my pleasure to moderate today's panel. In a country of over 300 million Americans, we're bound to disagree on pretty much every issue under the sun. So how is it that we have become the most successful nation in human history? Well, to begin with, I think it's because we look to our Constitution to establish a structure of government and a legal system that helps our people resolve their disputes, both big and small. But I think we also look to institutions of higher education to play an incredibly important role in educating not just the next generation of citizens, but the next generation of leaders. But in recent years, Americans of good faith are increasingly concerned that our institutions of higher education are failing badly in this responsibility. Many Americans worry that colleges and universities are no longer teaching an essential skill of citizenship, knowing how to agree to disagree with one another. Rather than educate, they indoctrinate. If someone disagrees with you, there's no need to discuss or debate, just deplatform and destroy. Instead of conversation, they encourage cancellation. And what happens on campus doesn't stay on campus. It affects the rest of the country. As a judge, I naturally focus on the state of law schools, and I see how intolerance in legal education is causing intolerance in the legal industry. We see this in the double standards that are routinely used when legal scholars talk about the judiciary. In the 6 years since I've been a judge, I've come to a simple understanding about academic commentary about the Supreme Court in particular. A lot of it is based on nothing more than this: too many academics view half the country as garbage. The Federal Society has put together a wonderful panel to help us sort through these issues. With us today are Aaron Sibarium of the Washington Free Beacon, Lori Ellen Moore, a law student at the University of Pennsylvania, Professor Stanley Fish, Presidential Scholar in Residence at the New College of Florida, and John McGinnis, George C. Dix Professor in Constitutional Law at the Northwestern University School of Law. I'd like to ask each of our panelists to give some introductory remarks. That'll be followed by some panel discussion. And as Lita mentioned, we will be sure to leave time for questions from the audience, which you can submit electronically, and I will choose among them. Aaron, would you like to get us started?
Sure. Thank you, Judge. So I have been tasked with providing a basic overview of the facts of the case, um, such that everyone on this call can appreciate why it's important, why it is in many ways a departure from what we've seen before, and why it has significant bearing on questions of academic freedom at the university. Um, and so I want to start by just kind of going through what exactly happened to Professor Wax, and highlight some of the details that I think have been lost in the public discussion, because the details are actually very significant to understanding why this is a big deal. So first, let's just start with the fact that Amy Wax is a tenured law professor. It is hard, supposed nearly impossible to fire or sanction tenured law professors, or at least it was until very recently. Typically, when a tenured professor is punished, they are punished for something like sexual misconduct, or outright academic fraud, something that does not in any obvious way implicate questions of academic freedom or speech. In Wax's case, though, the entire case against her is focused on speech acts, albeit speech acts that the school has tried to redescribe as a form of conduct, and we can get into that later. The controversy around her really started, I would say, in 2017 when she wrote this op-ed arguing that not all cultures are equal, bourgeois values are better for Western civilization and economic life. And I think most controversially, she made some sort of remark about how, not all cultures within America, including perhaps within our inner cities, sort of adhere to these bourgeois values. Nothing really happened as a result of it, except for a lot of outrage on social media, but that kind of set the stage for what happened next. So over the next 3 years, Wax makes a number of other controversial comments, almost all of which were made outside of the classroom. These are things she said on podcasts, on social media, in speeches, things like that, in some cases, even law review articles. And eventually she says something to the effect of, I rarely see Black law students graduate in the top half or fourth of the class. And that really amps up scrutiny on her. And the school actually, as early as 2021, launches an investigation into Wax's speech. Now, the key thing to understand about this investigation, which has not been widely discussed, is that it exonerated her of many of the charges that Penn would later use to sanction her. So she was exonerated and found not to have made specific statements that the law school later accused her of making. And other statements were found to have been taken out of context all the way back in 2021. And the most important finding of this investigation, which was completed by Daniel Rodriguez, the former dean of Northwestern Law School, was that Wax had not breached the confidentiality of student grades. She had not in any way discriminated in the grading of students. And that was really the key charge against her at that point, that Amy, by making these statements about the distribution of law school grades, was instilling a reasonable fear in Black law students that they would not be treated fairly. And this investigation, commissioned by Penn, basically found that that was entirely baseless. It did find that she made some, though not all, of the remarks she's been accused of making, but it didn't really recommend any particular course of discipline, and the law school just kind of sat on the report and it didn't do anything with it. So clearly, as of 2021, the law school did not think that any of this stuff was actionable. The problem is that, as anyone who knows Professor Wax can attest, she does not like to keep her mouth shut. And so she kept making controversial comments. And eventually on a podcast, she says something to the effect that more or less says that the United States should accept fewer Asian immigrants because Asian immigrants vote for Democrats. And she said that in a rather blunt way that really, really pissed people off. And so in early 2022, the school basically reopens some of the charges that it had tabled with this 2021 investigation, and then adds just a motherload of other allegations, statements that Wax allegedly made in the privacy of her home, statements she made in law review articles, peer-reviewed law review articles, statements to the effect that, DEI bureaucrats aren't very talented, DEI is poisoning the scientific establishment, things that basically every normal conservative and even many centrists and center-left liberals believe were added to the list of charges. And the school engages in this kind of Kafkaesque disciplinary process where they argue that all of these statements taken together amount to a form of discriminatory conduct, not speech, in virtue of which Wax violated the law school's policies and can legitimately be punished even though she's a tenured professor. They ultimately stop short of stripping her of tenure and firing her, but they do remove her named chair, dock her pay, strip her of summer pay in perpetuity, and impose a number of other sanctions. That was basically just a few months ago. I know the time's limited, so I just want to kind of draw your attention to a few salient facts about this sequence of events. The first is that there was arguably a form of double jeopardy here, right? And that the law school investigated Wax for specific statements, didn't take any action against her, and then reinvestigated her in effect after she said more controversial things and the pressure amped up to punish them. Second, many of the most serious allegations against her, including that she discriminated against Black law students in terms of grading, were found by the school's own investigation to simply be not true. And the school just ignored that finding. And third, I think there are some people here who will say, well, okay, they're sanctioning a tenured professor for speech. Okay, that's bad. But doesn't this stuff kind of happen all the time behind the scenes? People don't get their contracts renewed. People don't get tenure in the first place, et cetera, et cetera. And the answer is probably yes. But this case has been extremely high profile. It's been covered in the New York Times and other national outlets. Pretty much everyone involved in academic freedom issues knows about it. And simply by virtue of being so high profile, I think the case is going to have a chilling effect, far in excess of that associated with these kinds of behind the scenes cloak and dagger tenure cases, right? Everyone in academia kind of knows there's people who get screwed over and people dream up pretexts to punish professors for political speech. It happens all the time, but precisely because it's so cloak and dagger and behind closed doors, people don't know about it, and it doesn't send the kind of obvious message that punishing Amy Wax in full view of the entire world sends, which is that, if you make these comments, including that just sort of milquetoast conservative criticism of DEI, we consider that actionable conduct that can potentially jeopardize your tenure. That I really do think is new. And with that, I have a lot of other thoughts about this, but I don't want to monopolize the conversation, so I'll turn it over to my other panelists. Laura, you're muted, I
Thank
think.
you. Yeah, Lori, I think you're muted.
Okay, awesome. Am I now unmuted?
There you
Wonderful.
go.
So great. Thanks for that introduction, Aaron. I'm Lori Ellen Moore, current 3L at Penn Law. And in my introduction here, I want to bring up two main points. First, I'd like to discuss my experience in the classroom at Penn and how this pertains to some of the justifications the final letter put forth for imposing these sanctions against Amy Wax, specifically about negative learning environments and detrimental impacts on learning opportunities. And then I'd also like to suggest some considerations and frameworks for thinking through these free speech issues as they pertain both to universities generally, but also bring up some salient points that I think are specific to the law school environment as well. So in the letter that imposed the sanctions on Amy Wax, the school is emphatic that this is not an issue of free speech. It's about unprofessional conduct. It's about the fact that Amy Wax has had a detrimental impact on equal access to educational opportunities, that her dismissive treatment has negatively and inequitably impacted the learning environment, and she's created a hostile learning atmosphere. So I am currently in Amy Wax's class, her conservative legal thought class. When I walked in day one, Professor Wax established the rules saying you all can explore any point of view you would like. You can express any viewpoint. You can disagree with anyone in this classroom. The rule I have is that you have to be able to defend your viewpoint. And if you disagree with someone, you can't lobby a categorical label on them. You can't call someone a bigot, sexist, racist, insert topic here, phobe. You have to say, I disagree with you, and here's why, and defend your point. I'd like to contrast this with a couple of other experiences I've had inside the classrooms at the University of Pennsylvania. During my 1L contracts class, I was on call for our discussion of specific performance. And when we were discussing land specifically, pun slightly intended, I referenced Gone with the Wind. I said, well, so specific performance for land. Land is the only thing that lasts. It's the only thing in the world worth working for, fighting for, dying for. And my professor just goes sheet white and says, I think Gone with the Wind is horribly racist, and any reference to it is entirely problematic, and I will not have it in my classroom. And that was it. I was not allowed to speak for the rest of class for making a reference to an iconic movie in the cinematic canon here. In my first year constitutional law class, when going over originalism, I had a professor say, oh, originalism is just the dead hand of old men ruling over all of us. And it's frankly a morally untenable position because you get to conclusions like Dred Scott. And if we're really going about the idea that this is about professional conduct and not creating hostile learning environments or shutting students down, I really don't see how Amy Wax's presentation of how to discuss ideas in a classroom and some of these inter-classroom dynamics that I've seen from other professors, I don't see how you could distinguish those. I think there's very much an argument you could make that the other experiences, putting a moral label on a position held by more than half of the federal judiciary probably, and shutting a student down for making reference to a widely acclaimed and regarded piece of popular culture, are in any way positive learning environments, or at least anything that's not equally detrimental to something Amy Wax could do. So all of this leads me to think that this has to be inexorably tied with freedom of speech values, which I'd like to lead into my next consideration here. If we're thinking about, all right, if we have a guidebook, if this is truly about conduct, if it's about speech, how do we decide what goes in this? And I think all of this has to be tied back to the function and the mission of a university, which is going to be the pursuit of truth. Effectuating that mission requires you uphold conditions of freedom in the classroom, which means you have to have open and free exchange of ideas. It necessitates having intellectual diversity so you can have a platform to hear those ideas, hear the best things presented by both sides, grapple with them, use that sparring to advance or discover more about the truth, and have those platforms where people can disagree. That's really not happening in a lot of ways. I'd also like to suggest that for the law school context specifically, law schools are not just a subset of academia where we're pursuing truth, but they're also professional schools where students are supposed to be trained to be advocates and effective lawyers. And part of that is having the ability to know how to think and not just what to think, how to make a good argument. But we're more than that. We are advocates who are presenting in front of judges who decide the merits of our arguments. We have a federal judiciary, a lot of whom adhere to originalist philosophy or find originalist ideas very persuasive. And as an example from my First Amendment or first year constitutional law class, a lot of academia is very hostile to originalism. My experience, and I think this is reflected by that of many of my classmates, both at Penn and at peer institutions, is that originalism is really not given a fair day in court in the law school classrooms. It's the tyrannical scepter of old dead men, and it's dismissed out of hand as nothing more than that. The problem with this is that it's not only injurious to the pursuit of truth, but I think it's an abject failure to train us for our professions. And we have lots of judges who are making decisions and want to hear originalist arguments. We need to be able to understand originalism. We need to know how to think through these questions, even if you don't like it or disagree with it. Being able to understand where this comes from, how and why will make you a better advocate for saying, here's why I disagree with it, and here's why you should too. So I think within the law context, especially, we also need an academy that is reflecting the realities on the ground. What are the forms of argumentation we need to be able to make? Because we're not only pursuing truth and justice, which we should do as lawyers and future lawyers, but we need to be able to be effective advocates. And without an environment that is conducive to those exchange of ideas, that is presenting arguments that are actually effective on the ground fairly, the law schools are failing us not only as good, virtuous citizens, but as future lawyers entirely. So I'll leave it at that to start.
Wonderful. Thank you, Lori. Let's see, I think Professor Fish is next.
Thank you very much. I'm going to make more general remarks than have been made by my two predecessors and reserve my perspective on the Amy Wax situation in particular for the discussion between us. Because I wanted to establish some definitions and guidelines in thinking about the relationship between free speech and academic freedom and work, academic work in colleges and universities. Let me lay my cards on the table immediately by saying something that you might find counterintuitive. Free speech is not an academic value. And that's the basis of everything that I want to say. Finally, I think about the Amy Wax situation. What do I mean by that? I mean by that free speech is a political value. It's a value tied to the principles of democracy. And it's a value which assumes that citizens are equally enfranchised to speak on issues and matters of public concern. And as many of you know, the phrase matters of public concern is a term in the academic discourse. What this means is that in an ideal sense, at least, not regarding limitations of funding and opportunities, in an ideal sense, every citizen has an equal right to pronounce or to dispute matters of public concern. The academy, however, operates under a quite different principles. There is no one who would suggest that everyone in a class or everyone who applies for a job in a university has an equal right to say whatever he or she thinks and to be either rewarded or tolerated for that speech. Much of the machinery in the world of academics, of the academy, is an exclusionary machinery. It is designed to determine who will not be heard in the classroom or in our publications, learned journals, and monographs. That is, it is the business of tenure and promotion committees, of dean's committees, of chancellor's committees, of the editors of learned journal to say to a prospective candidate who wishes to possess a podium, no, you're not going to be heard. We're going to send you away. And I'm pretty sure that the ratio of people who apply to be in possession of the podium and people who are sent away is largely in favor of people who are sent away. More people are excluded from the academic process of inquiry, then are admitted into it. This is because freedom of speech is one thing, as I've already said, a political value, whereas freedom of inquiry is the academic value. And freedom of inquiry does demand a certain form of freedom. It's the freedom to follow the evidence wherever it leads. Therefore, it's the evidence that is calling the tune, not the free choices of you as an instructor or someone as a student. It's the evidence that is calling the tune, and that you, as an inquirer, pronounce as that evidence allows and dictates that you pronounce. That is the only freedom, I think, that belongs to the instructor in a classroom or to the researcher who is writing an essay or writing up an experiment. It is not the general freedom to say what you like on matters or issues you deem important. It is the very specific or guild freedom to do the job that you have been trained to do and that you are presently paid to do. We are not, we as academics, at least I am an academic, and so is John McGinnis, of course, we are not either in the democracy business or in the free speech business. We are in the academic business. And the work that we do has to be ruled by, governed by academic protocols. In terms of academic activity, especially the activity of teaching, the key test always should be, is what I am saying or presenting to my students designed to further their understanding of the issues at contest in my course, or is it designed to nudge my students in the direction of some political or ideological belief? That's the test. Given that test, it follows that anything can be introduced into the classroom, so long as it is regarded in academic terms, held at arm's length, as it were, and made the subject or object of academic interrogation. What is its structure? Where does it come from? What is it affiliated with? What is the history of its emergence, et cetera, et cetera, et cetera. We are not only free to do that, we are, as academics, obligated to do that. And we are not, as academics, free to do anything else. And finally, I would extend this, of course, to universities, which as corporate entities are free to pronounce on matters directly related to the health of higher education, but are not free to pronounce on other matters, as if the existence of an advanced degree gave you a certificate in general wisdom. No certificate in general wisdom is given either to academics or to academic institutions. So that my final message is that academics, both individual academics and corporate academic entities, should stick to their own knitting. Or as I put it in a three-part mantra long ago, A, do your job. B, don't try to do anyone else's job. C, don't let anyone else do your job. That's it. There's nothing more to be said about academic freedom, and free speech has nothing to do with it.
Thank you. Very, very interesting, Professor. Professor McGinnis.
Well, thank you very much. I'm very grateful for the opportunity Federal Society has given me to talk about these things. I'm going to do two things in my remarks. One, I'll have a very brief response in some ways to Professor Fish's remarks. And then I want to spend most of my time talking actually about the report of the University of Pennsylvania, which it used to justify Amy Wax, to punish Amy Wax. There'll be some relation between those subjects. So I'm in general have some great sympathy with Professor Fish's position as an ideal matter, as a regulative ideal matter. The university has a different function, as he points out, than the political realm. And peer review is what disciplines what professionals in the university can say. And I think there's a lot to that. The difficulty, of course, is the way, twofold, I think. One is more generally with the universities as they exist today, how will that work in a university world where universities already have allowed politics to come in the door, both institutionally and, as we've heard from Ms. Moore, through individual professors, which I don't think share Professor Fish's view of their mission, and which have one ideological view, just monochromatically, almost to the left. How actually will ideas get a fair hearing in that world unless you actually expand, at least for tenured professors, give them some free speech as opposed to academic freedom rights, because academic freedom will actually turn out not to protect them because their peers will be ideologically biased. The other question, I think, and this is just a genuine question I have, is how does academic freedom translate in the law school context? Law schools are professional schools where people are trained to be advocates. That's a little different from actually simply training to get people to get the truth. And that may also suggest that you want to have a bit wider freedoms in the law school context than you might have, for instance, in chemistry or even in English literature. And the ABA has recently, and I'll put this on the table as well, has actually suggested that there are free speech rights that all participants in law schools need to have. That's Section 208 of the APA, and that is being implemented at all law schools. So it's actually a positive matter. There are going to be free speech rights in law schools. Maybe that's a mistake, but I think in some sense that's a reaction to the peculiar function of law schools in the academy. So let me turn briefly to the opinion with which Amy Wax was disciplined, because I think this is, in some sense, a travesty of academic freedom. It's really quite, even if you believe that only academic freedom rather than free speech should be protected, this is a great danger to academic freedom. And I'll just make 3 points about it. I'll make rather specific points, but I think they are quite general. So first of all, the opinion doesn't actually show how some of Professor Wax's opinions are against the peer views of in the academic discipline. Again, it's a little hard with law schools professors because often they use their kind of bricoleurs. They use different disciplines. So one thing Professor Wax is disciplined for saying is that different groups have different cognitive abilities. The opinion doesn't, on average, he's very clear to say on average, very clear to say that, and the opinion doesn't actually show why that is false or why that is thought to be false among psychometricians. And of course, at least insofar as SAT scores are considered to be cognitive tests, different groups do score on average, again, have different scores. And indeed, that is the whole premise of why we have affirmative action and why there's been a debate about the wisdom of affirmative action. So it's very strange that this report uses this as a way to indict and indeed to discipline Amy Wax without actually going through any discussion of whether this statement reflects something that is against the views of the relevant peers in the discipline, which I would assume would be psychometricians. I don't believe any of the authors of this report, which were a group of faculty, a committee, are in that discipline, and they don't actually show that it's false at all. Secondly, in this report, they also suggest that she has, quote, an uncritical use of data without actually telling us what's wrong with her use of data, just that it is uncritical. As an empirical colleague of mine said, this claim could be made against almost any use of empirical data that is in some sense uncritical. And if this were used in a neutral fashion, this would have a chilling effect not only in controversial areas, but in areas right across any use of empirical data. People will be worried that they're going to be accused of it being not sufficiently critical of it. Of course, maybe there's not going to be such a chilling effect across any use of empirical data. And that gets to my final point on this report, which is quite clear that this report in some sense, is not viewpoint neutral. The report in and of itself says that we're very worried about these things because they harm the identity of certain people's identity, and that they are harmful to certain minorities, suggesting that perhaps the same kind of language, if it were made against groups that were in the majority, might not be subject to discipline. And this again goes back to the first part of my remarks, that there seems to be a political viewpoint behind this report, and it suggests why academic freedom may not be enough to protect people who have minority viewpoints in the academic world, because it will not be applied in a neutral manner. So I think, in conclusion, if you look carefully at this report, it even on the view that it is trying to a narrow view of academic freedom, it does not show how Professor Wax has violated academic freedom. Indeed, in some sense, itself is a report that is inconsistent with academic freedom by not focusing on standards of peer review, either generally or in specific cases. So this raises the question of how, given that the University of Pennsylvania is a very well-regarded institution, how academic freedom can serve to protect the viewpoints, unpopular viewpoints that may well have roots, though, in accepted aspects of discipline today, and raises questions about the whole relation of academic freedom and whether it is sufficient, particularly in the law school context, to defend what is the common good of the law school. I think that Ms. Moore has suggested ventilating viewpoints, teaching people how to be advocates when people, even with statements that might well be accepted by peer review, can be disciplined during their use of them in an advocacy manner. Thank you.
Thank you, Professor. We'll start some panel discussion now. Let me begin by just opening this up to the entire group. Has anybody said anything during the opening presentations that you'd like to respond to and engage on?
Well, I would just underscore something that Professor McGinnis was gesturing towards, which is that, we do not live in, I think, the kind of ideal world outlined by Professor Fish. These universities have been making political statements, and engaging as political actors in many ways for years. And indeed, it's worth underscoring that Penn's treatment of Professor Wax is totally inconsistent, not just with the representations that it has made to the United States Congress under oath, but also with its own disciplinary actions towards other professors. So you'll remember that Liz McGill told Congress that, Penn voluntarily follows the First Amendment. That's what Penn said. So even if the university shouldn't be seen as a kind of free speech zone, or free speech is not actually an academic value, even if all that's right, it's important to underscore that the University of Pennsylvania does not agree with that. It has taken the position in front of the United States Congress that that is not how Penn sees itself. That's point number one. Point number two is that the University of Pennsylvania has declined to punish professors for speech that I think any reasonable person would regard as at least equally offensive and controversial, if not more so, than what Professor Wax has said. And the most clear-cut example is that Penn declined to punish a professor who published all sorts of cartoons depicting Israelis drinking the blood of Gazan children. We could debate whether the university should even be employing such a cartoonist in the first place in any capacity. That's a separate debate, but they do. And the professor published this in an extramural context, right? It's extramural speech that some people found offensive, just like Professor Wax. But the university said, well, it's offensive, but, you know, free speech, First Amendment, we can't do anything about it. So, you know, again, I'm totally happy to have a debate about what Penn's policy should be, what the ideal of the university is, whether it should be seen more like a guild or more like some other thing. Those are all very important debates to have, but I just want to be sure we're starting with an acknowledgement of the facts that Penn, it does not really seem to see itself that way, and does indeed display a rather, I think, astonishing hypocrisy in terms of what speech it tolerates and what speech it doesn't. And I'll just note one last thing is that Professor McGinnis talked about, you know, following the evidence and that the school hasn't actually showed why anything Amy said was wrong. Well, putting aside the merits of Amy's views, it's worth noting that a lot of her statements are empirical claims about the world. They may be wrong, but she's making an empirical claim about the distribution of cognitive ability on average across racial groups. That's a social scientific claim. Cartoons depicting Bibi Netanyahu with fangs drinking the blood of Gazan children out of a wine glass, I think, is less obviously a kind of academic or empirical argument in the way that what Amy said was. So that's just another framing context point to keep in mind, and I'll stop.
Thank you. Professor Fish, you seemed very eager to respond.
Well, I'm glad you stopped, Aaron. I was worried there for a while. Look, let me further identify myself. I am a Penn graduate. I am a very strong card-carrying originalist. And I am someone who has written extensively on these issues, a book on academic freedom and several books on the academy in general. And I do, of course, acknowledge what Aaron and Professor McGinnis has said, that the ideal that I sketched out in my opening remarks is by no means fulfilled by the University of Pennsylvania and others. I will, however, point to a development in recent months, which I find promising, and that is a development that university after university has declared itself to adhere to what is generally known as the Harry Calvin Standard, one that I've been urging for years, which says, in effect, that it's not the business of universities to pronounce on matters other than the matters directly affecting the health of higher education. They're not supposed to go there, and they shouldn't go there. And when they do go there, they have crossed the line between being educational institutions and become political agents of some kind. Now, the universities and colleges which have found this new truth have not done so, I believe, I'm only guessing, out of conviction or less, even less out of a religious conversion. Rather, they are scared. They are frightened by what they saw happen to the presidents of University of Pennsylvania and the presidents of Harvard and the president of Columbia, and they don't want it to happen to them. So they have no doubt consulted their offices of legal counsel, all made up of persons whose only business is to avoid controversy as much as possible. And they have been told, stay away from that, adopt a hands-off policy. Well, I'm hoping, and it may be a vain hope, that that movement, as I said, born out of fear rather than of conviction, will lead people to reconsider the entire question in the direction that everyone on this panel approves of. And that is the directions of having an academic activity, which is truly academic, and one that is not infected from the beginning or in the middle or at the end by politics. And I think that this may, in fact, happen, and I'm sure it does happen in many classrooms. It happens in mine. I'm sure it happens in John's. I'm sure it happens in some classes that Lori has attended.
I have a question I think mostly to you, Professor Fish, but maybe Professor McGinnis may also have thoughts on this. I've heard a lot of academic versus political acting, or senses that we should follow the empirical data, but maybe things that are political are not the place of academic functions. And I think my question here is, how are we distinguishing between what's academic and what's political? Is political
That's
mean,
easy. That's easy.
well, because I think my kind of follow up there as well, if there are things that are political, is this a cause taken up by political actors, issues you see debated in politics? Will that not unnecessarily and perhaps problematically cabin off some areas of inquiry for the universities? So if something becomes a political issue, a political cause, does that mean universities can no longer pursue and investigate and talk about these things in the way in which you would want them? I see that as a potential issue or an ideological valence problem in thinking about the freedom of inquiry that I think we all on this panel think is a good thing and should be happening.
Well, look, it's very easy to distinguish between academic and political issues. Let me repeat that there is no issue that cannot be brought into the classroom, so long as it is the object of academic interrogation and not a candidate either for moral acceptance or moral rejection. No matter what the issue is, no matter how contested it is in the real world, you should, and this is a word that I've invented, academicize it. Take it away from the real world urgency context where you're making a decision which will lead you to go out perhaps and march or vote or contribute to a cause, and instead inserting the issue, whatever it is, into an academic context where you're inquiring into its origin, its structures, its adherence, its relationships to other issues. So again, as long as you hold the issue at academics' arm's length and interrogate it through that lens, no issue, including the most politically charged issues, are out of the classroom, because they will not be political in the incorrect sense in the classroom. They will become like any other objects of study, and study is what we do.
Well, again, I'm worried about how this will work in practice. I'm very, like Professor Fish, I'm very enthusiastic about universities committing themselves to institutional neutrality. But universities work through people. They work through professors. There was a group of professors who wrote this report on Amy Wax. And the difficulty in our universities today is, I think there are many professors who actually think that the universities should have a political valence. And regardless of whether there's a statement that the president won't put out these statements, they will operate still through political ends. And I think, as I've tried to demonstrate, that this report on Amy Wax is infused with politics, and in fact is, in some sense, violates, in my view, the norms of academic freedom, because it doesn't actually evaluate statements according to professional norms. It is a violation, in some sense, of academic freedom. I don't quite see how we're going to get back to what I accept from Professor Fish as an ideal world, in a world with the people who are populating the university today, as demonstrated by this report. And if I just might add one other point, this report was only instigated by a decision of the dean to bring a variety of charges, which included many more charges than are actually discussed in this report, including another charge that Professor Wax had an interview with Enoch Powell. She showed a video of an interview with Enoch Powell, which he said, the dean said, was impermissible, was Enoch Powell was a well-known racist. Well, I don't believe the dean of the University of Pennsylvania Law School was an expert on British politics. And there actually has been an academic article written showing that much of what he said is at least contestable and largely false about Enoch Powell. And that again demonstrates that in our world, for whatever political, bureaucratic reasons, he was willing to make charges outside of his own discipline to attack one of his colleagues. And I don't see how that can be easily prevented unless we have the kind of strong safeguards of free speech, at least for tenured professors. Of course, free speech just reflects a distrust of our of government, and when as we put it in the university context, it reflects a distrust of the political motivations of deans and of committees like the one that disciplined Amy Wax. And so I think that might be the second best solution because of at least on the basis of the evidence we see in this case.
Could I, or Professor Fish, you can go ahead.
I agree that with John's assessment of the Enoch Powell matter, and I would just add to it the accusation made by this report, which is as shoddy and flawed as a report could be. The accusation made that Amy Wax invited Jared Taylor, quote unquote, a known white supremacist, unquote, to her class. The mistake here is a typical one in context of documents like this. It's a mistake to think that when you invite someone to a class, you are endorsing his or her beliefs and declaring them in some way to be true. It's the same mistake that you would make if you censured a teacher for assigning either Das Kapital or Mein Kampf, as if the assigning of these texts were an indication that the instructor embraced the sentiments contained in them. All of these are effects of the cause that I tried to identify before, the inability of many to distinguish between academic questions and political questions. And I agree also with John McGinnis that there are many faculty members who display that inability, and unfortunately, even more administrators who do. So I would call, and it's just a call out of nowhere, no one is going to respond to it, I suppose, but I would call for different kinds of administrators who know that they are not in the free speech business and that they are not in the democracy business, but that they are in the business of presiding over intellectual inquiry, that journey, and know exactly what it is, and know, therefore, what should be encouraged and what should be curtailed if it occurs. That might also fall under the rubric of the ideal that is not going to be realized. But I'm not sure that efforts such as, for example, the effort proposed by a friend of mine, intellectual diversity, efforts like intellectual diversity will do anything but increase the level of politicization in the university.
So I want to just make a couple points about the politicization question, because I think there's often a tension in these arguments. So on the one hand, people will say, well, these schools are cynically adopting institutional neutrality, kind of, but it's still a good thing, so let's accept it, And then on the other hand, say, well, but we don't want politicians interfering in the autonomy of these schools. Well, the thing is, the reason the schools are adopting institutional neutrality is because they are afraid of politicians dragging them in front of Congress and humiliating them and regulating them. And so the salutary effects of this policy of kind of depoliticization in fact flow from a political act. Now, to be fair, I would note that part of why Penn decided to go after Amy in the first place is that there were actually Philadelphia and Pennsylvania, like local politicians, who were giving Penn shit, pardon my French, for continuing to employ Wax. So it is absolutely the case that outside pressure from politicians can have a speech suppressive effect, can stifle free inquiry, all of that. But I think it's also the case, as we've seen since December 2023, that political intervention, even political intervention that manifests as a kind of unprincipled grandstanding on the part of elected Republicans, does seem to have had, I think, some salutary effects. So, there's always I'm not saying that the GOP should just go full on, we're going to remake universities in our image. I'm not saying that there are no serious risks associated with political pressure, but I do just want to make the case that sometimes political pressure is important to if you're trying to nudge institutions, ostensibly private institutions, towards a regulative ideal. And I don't think that it would be right to conclude from the past couple of years that all forms of political pressure on universities are negative or necessarily undermine their mission. In fact, I think the picture is really a lot more mixed than that.
Aaron, let me ask this. Is there a difference, and this is not just for Aaron, it's for everybody, is there a difference between outside pressure that is motivated to further a particular political position, pressure to make something more left or more right or what have you, a difference between that and pressure on schools to be more neutral, to be more like schools, if you will? Could we say that there's some outside pressure that has a, Title VI and Title IX push schools in a particular direction, that can be for neutral purposes, or it could be to pursue a particular agenda on one point on the political spectrum? Is there a difference between those two?
I think in theory, yes, but in practice, any kind of political pressure is going to be kind of imbricated with particular agendas, even if those agendas remain implicit, or even if they're contested. So I obviously, look, if I were advising congressional Republicans or the next administration, not that anyone's asked me, but I would tell them, look, I think you guys should try to make your pressure as apolitical as possible and focus more on just, we want the universities to be dedicated to something like what Professor Fish outlined. And so, we're gonna revisit, federal funding and accreditation. But if you guys just commit to sort of, cutting it out and being more neutral, middle of the road, and getting back to what you're supposed to be doing, we'll ease off. That's what I would tell them to do. I mean, I just would say that, realistically, the notion that the outside pressure is going to be totally divorced from a particular partisan agenda, that's a nice ideal that we can aspire to, but let's not delude ourselves into thinking that it's going to be perfectly realized. I mean, we are where we are.
I think the some of the most successful ways of trying to show is to demonstrate these ideals. And in my experience, some of these new civic education colleges established within universities have been really exemplify many of the ideals. They have, I think, hiring practices that are not trying to be try to get viewpoint diversity, but they are trying not to discriminate against certain viewpoints, and that's very helpful. They try to actually have programs that have a variety of viewpoints, unlike legacy colleges and universities. And that demonstration effect, I think, is the most powerful way to get back to some of the ideals that Professor Fish has outlined for us. We have another problem, though, with these legacy structures. How do we get them to function? And there I'm much more pessimistic, at least unless we have a generation of professors who will help us by dying off. Because until that changes, I just do not see universities as getting out of the political business on the ground in the day-to-day, whatever their administrators say in statements. Because that's been my experience within my own university, and I think with many others within their universities and what we've heard today. So my advice, my political advice, would be to, on the one hand, try to agitate for pretty broad free speech rights within legacy universities, but then try to have the demonstration values of some of these civic institutions, which I think can go back more towards these apolitical, academically focused institutions that Professor Fish celebrates and that I also would very much aspire to.
Professor Fish.
Well, first of all, this is ungenerous, but Aaron, when I was the director of the university press at Duke, I said, we shall not publish any book which uses the word, in which the author uses the word imbricate. So drop that word from your vocabulary. I would also want to resist the suggestion made in John McGinnis's recent remarks, and also I think suggested by some of Laura's remarks, that variety of perspectives is a good thing in and of itself. Variety of perspectives is not a good thing in itself. What you're after is, in academic inquiry, is not a variety of perspectives, but the introduction of perspectives that have proven themselves to be useful in the search for truth. The only kind of course, and I do teach such courses, in which a variety of perspectives is to be presented, is what used to be called a survey course in the liberal arts context, or in my jurisprudence course in the law school, where we survey at least 14 or 15 general approaches to the law and constitutional questions. There, the title of the course determines the obligation of the instructor. That is, to introduce a variety of perspectives. But when I teach my course on John Milton, my perspective on Milton is resolutely theological, taught through the context of his religious beliefs. And while there are many other Miltonists equally as credentialed as I am who teach other kinds of Milton, I feel no obligation even to acknowledge their existence in my course.
So,
Can I push back though on that? Go ahead, Professor, and then Laurie.
So again, I think I'm here between the ideal and the reality. I certainly agree, of course, that in any particular course, there can be no requirement that all viewpoints be represented. And I also agree that not all, it's in some sense incoherent to require all viewpoints to be represented. Some are better than others. But what we want to prevent is discrimination. Let's go to the law school context of we're not going to have any discussion of originalism, or we're not going to hire any originalists. And I've heard professors actually say that we're not going to hire any originalists. That's the reality we have on the ground. And in that reality, given that reality, the idea that we should encourage a greater number of plausible viewpoints is a way of fighting against the discriminatory structure we have in hiring and indeed in debating issues today. So again, it's a second best alternative to get to our to what I think should be our alternative, the best, the first best, which is where we don't actually focus on people's viewpoints, but just how powerful they are. That I don't think can be where we are today, in a world where I think there is kind of rampant discrimination against certain viewpoints in an attempt to actually prevent them from being heard, particularly in a law school context where we at least want to hear some of the viewpoints that are expressed, that can be expressed methodologically in litigation.
Yeah, what I'm hearing, just to summarize, is Professor Fish is making the case that the only standard should be what I'll just loosely call academic excellence, unconstrained by any particular regulatory structure. And what Professor McGinnis is saying in response is that's a nice theory, but we just can't trust people anymore in these institutions. And so the second best, to use your word, I think that's exactly right. Second best is a non-discrimination framework. Lori, you certainly have been patient about wanting to say something.
Yes, I think my remarks will certainly echo some of what Professor McGinnis said here. But I think part of the issue here, I'm definitely not advocating that intellectual diversity is good on its face. I also agree with you, Professor Fish, that it's the things that are in pursuit of truth that are useful, and there are going to be some viewpoints that are better than others, worse than others. But one of the things you said is also proven to be useful in the pursuit of truth. And the only way we can get to determining whether an idea is worth expressing in the classroom, whether that be individually, whether that be represented in the institutions, is having the opportunity for that viewpoint to be proven one way or the other. And the issue, as Professor McGinnis was saying, if we're thinking about the legal context, and I think this is certainly true in other academic contexts as well, is that we're in a situation where the originalist perspective, some perspectives are not being discussed in the classroom at all. You're not hiring people, you're not able to discuss them, they're not getting a fair opportunity to be heard, to have the chance to be proven. If we're thinking about the 12b6 motion to dismiss standard here, all right, if we're going to take something as true and take all reasonable inferences, great, we're starting there, and then we argue the merits. Right now, we're dismissing the well-pleaded facts and not considering them as true here. So all that say, and my other point that I wanted to make is the removing everything and holding it at arm's length sounds like a very nice, neat, removed and high-minded way to go about things. But the reality is, when we're thinking about any of these things, there of course is going to be moral valence. Even saying we should think of this as neutral, that's a value judgment we're inserting here. So I may push back on the idea that we can really have an entirely academic or at arm's length focus for really any of these issues. Thinking about looking at the Apology of Socrates or some of the founding documents in Virginia with the freedom of expression and conscience that they put out in their Bill of Rights, the idea of freedom of conscience and expression are inexorably tied together here. So there's always going to be a moral valence and idea with the things we're discussing, particularly in the legal context when we're going out and fighting for justice and all of these causes that are going to have very strong moral issues and valences attached to them. We need to be able to discuss them in the classroom. And it's just not realistic to say you're not going to have a value judgment or a moral sense one way or the other in the classroom, either individually. Hopefully at a university level, you can at least give the space to have these issues heard fairly on either side, whether or not the professor is advocating with a bias towards one way or the other. But there is going to be a moral valence, and we have to accept that. And we can't have more morally charged issues as we therefore can't discuss these because these are political.
I've never said that you can't discuss morally charged issues, only that when they come into the context of a classroom discussion, they are no longer morally charged. They're issues that should be examined. And if you think it can't be done, I invite you to my classroom on any subject. I do it all the time, and I know other people who do it. The fact that there is going to be a moral valence somewhere is, of course, true. Depends on whether it's up front or not. Do you come into class with the moral valence up front? That's what I'm going to do. I'm going to, quote unquote, teach for social justice. Or rather, do you come into class with the intention and the dedication to the principle of academic interrogation as free from political concerns and perspectives as possible? There certainly is a difference, as there is a difference between, let's say, a faculty member who goes into a department meeting thinking, I know what I want, how I want this to come out, and I'm going to say things that ensure that it comes out this way. Or someone who says, I think I know how I want this to come out, but I'm going to listen to what other people say and be open to changing of mind. There's a difference between those two positions, even though the people who hold those positions are also possessed at some level of a moral valence. So I think it can be done. All you have to do is be a professional. These are professional issues. I am against the moralization of all of this. I think we should, whether we're on the left or the right, get off our high horses and talk about the way things work. And finally, to a point of Professor McGinnis's, the idea that originalism would not be taught in law schools is not only bizarre from a moral or academic freedom point of view. It's bizarre from a professional point of view. In a world where over half of your Supreme Court justices are originalists, and where leading judges in the circuits are also originalists, how can you not teach originalism? It's a professional responsibility to do so. It's an academic responsibility to do so.
Yeah, I want to turn to some of the questions we've received from the audience, but what you just said, Professor Fish, and some of what Lori has been saying as well about her classroom experience, compels me to just share a quick personal story. I had a great time in both college and law school. I sort of despair for the current generation because they're not getting the educational experiences largely that I just loved and enjoyed. One experience in law school, I'd written a few op-eds against racial preferences, so my views were sort of known to the professors. In one class, con law class, the professor asked me, as part of the Socratic process, to defend racial preferences for various perspectives. I thought that was wonderful. Lori, what you said is you go to law school in particular to learn how to argue. To me, what that means is lawyers, every law student should know how to argue both sides of various issues, including sides that they personally find disagreeable. And I worry that that's what we've lost. We're now teaching activists rather than advocates. One question, there's so many good questions. I want to do, there's one that I'll just throw out there. Should universities look outside of academia for administrators?
As a former university administrator, my answer to that question is, in general, no. Because although there's a belief that an administrator who is experienced can administrate anything, I would argue instead that your ability to administrate an academic context requires your familiarity with that context. Because the academic context is very odd. It's a context where, in some sense, there is no product that can be assessed on a quarterly basis. And there's no penalty in the academy for embarking on a project that you never quite complete, or a project that when half completed, you turn around and begin all over again in another direction. That's very odd. The academic enterprise is very, very odd. And I think it takes an administrator who has been a participant in that oddness.
I think I agree with that. And I think one of the problems in academics is even the academics who become administrators now are really become on a separate administrative track. And they therefore lose often some of the values of academics and are interested in simply politically positioning their institution. I think perhaps, again, this is an example from Professor Wax. The dean feels under political pressure and doesn't really reflect academic values because he's on a cursus honorum or a cursus dishonorum often. A dean becomes a president, and therefore his focus is on non-academic values, but how to focus on his career and avoid controversy. So I think one of the stories of the decline of universities actually has been, even within the university context, the separation of a kind of class of academic administrators from the faculty.
Okay. Another question, law school education is subsidized by federal student loan programs. If natural rights like free speech are anathema to certain law school faculties, should tax dollars continue to subsidize those law schools?
Yeah, I mean, so I think this question is really getting at a broader issue, which is the incredibly public role of universities, right? We say that these things are private institutions, but they're not just private institutions. They get tons of taxpayer subsidies. It's not just student loans. Their endowments enjoy tax-exempt status. You know, a decision we make, right, because we take them to be providing some kind of public good, right? This is why we give nonprofits tax exempt status, because we think the nonprofits are doing something important that we value and think should be rewarded. And then the other way in which these places are public is that they produce the elites and ideas that end up exerting power over the apparatus of government. And so, look, obviously, they are still private institutions. Obviously, that designation or categorization has some meaning, and I'm not proposing that we nationalize all of the universities. But I do think it's legitimate to ask, are these institutions doing what we have given them tax exemptions to do? Are they doing it well? And if not, should they continue to enjoy those special privileges? I think that's a totally fair question.
Yes, it is. Yes, it is.
It's a fair question, and I think it's a question that goes to the heart of the debate in conservatism today. But I worry, although I'm very skeptical of how universities are performing, about allowing the government to make those kinds of decisions rather than have more broader discussions. We allow people to have a tax deduction for general charitable enterprises. Once we allow the government to do that, I think we may lose some of the kind of spontaneous order and innovation. And I'm much more hopeful that we'll see some correction here. I think we have seen some correction coming out of these Gaza protests and the energizing of trustees in nonprofit institutions to try to correct the course. I'm much more comfortable with that than inviting the government in to make these distinctions, because let me tell you, won't be the only distinctions they make. They'll start making other distinctions that I think, Aaron, you won't be so happy with some other kind of administration. This, I think, is a central issue for conservatism today, because the question of whether private power is more dangerous than government power is one that is perhaps the biggest issue fragmenting people on the right. So it's not only about universities, but generally. And I'm afraid, as an old Reagan Republican, even with the worries that I have about universities, I worry about going down a road where the government would make those sorts of distinctions.
This brings us back, I think, to the 1915 Declaration on Academic Freedom and Tenure by the then fledgling American Association of University Professors. And the point was made very strongly that it's incumbent upon universities and colleges to police their own shops, because if they don't, some other constituencies will always be eager to come in and do the job, and as John suggested, do more than the job. So that I think it's absolutely imperative that universities and colleges, even if they are impelled by the political forces that Aaron spoke of a few moments ago, that they re-examine their positions and realize, for example, with respect to the protests on college campuses in recent months, that there is no academic right to protest. There simply isn't anyone. You couldn't find an academic right to protest. And therefore, those who declare that there is one simply don't understand the nature and scope of the academic task. And as I've said before, the problem is that there are too many administrators who are in that category.
So I've got a question that I think is a follow-up to that discussion. How do we hold universities accountable for protecting and preserving free speech, considering that so many administrators are intolerant of dissent?
Well, this is where I do think that political pressure can be useful. And I would just say, in response to Professor McGinnis's point, I agree that if you start, there's a real danger that we throw the baby out with the bathwater, and that the politicization of the universities just consumes them entirely. But there's a lot of kind of intermediate steps that can be taken that I think do not obviously put us on the path towards like the total destruction of academia, right? Political actions that I think are more prudent or at least defensible. For example, here's a kind of technocratic one. You know, part of why law schools have engaged in some of the DEI excesses is because they're now effectively mandated to by the American Bar Association, and which is their accreditor. And the reason they have to care what their accreditor thinks is because the Department of Education recognizes the American Bar Association as the only legitimate accreditor of law schools, which means you need an ABA accreditation to receive federal funding. What would happen hypothetically if a Secretary of Education just said to the ABA, you know, we're not sure you're doing such a great job of accrediting law schools. We'd really like you to cut out the DEI stuff, you know, and if you don't, we might revisit your kind of accreditation monopoly. I suspect that if you did something like that, you'd see the ABA buckle pretty quickly. Could be wrong, but you know, that's a way that you can kind of leverage the threat of government action against the accreditor, not the universities themselves, and, you know, remove probably one of the pressures that is pushing schools to engage in the kind of crazy political stuff that we've been criticizing throughout this call. You know, another example that's more controversial, but it's actually something Amy Wax herself has proposed, is that just as Title VI already says that, or Title IX already says that you can't receive federal funding if you discriminate against on the basis of gender, right, in education, and Title VI says that you can't receive federal funding if you discriminate on the basis of race, you could just sort of create a new law that says, well, if you receive federal funding, you have to adhere to the First Amendment or at least come very close to it. There are problems associated with that. We could get into those. But the key point is, like, we've already said that there is certain non-criminal conduct that schools nonetheless can't engage in. And we've said that they do not have the institutional autonomy rights to allow discrimination based on race and gender. So in principle, I'm just not sure why it would be wrong to further constrain their autonomy in a definitionally viewpoint neutral way and say, actually, you guys have to have free speech policies that reflect the First Amendment, and if you don't, you can't get federal funding. Again, you can debate the merits of that, but I don't think that that's some kind of crazy departure from precedents that we've already set and accepted. So those are just two examples.
Let me just point out that the first example that Aaron gave isn't really getting government more involved, it's getting government less involved. It's taking away a government monopoly on accreditation. And so I certainly think that's something that should get both enthusiastic support from more libertarian conservatives and others. There's nothing wrong with that, and that I think would be a very sensible idea for an incoming administration, not to name any in particular.
One question.
Go
ahead, please.
I would just reiterate my early statement that free speech is not, in fact, and should not be the focus of our discussions here. Rather, it should be freedom of inquiry, and introducing free speech and free speech rights merely over-moralizes what I think of as a professional or guild set of activities and problems. I always argue, my arguments are always deflationary. Aim low. If you aim high and invoke certain honored abstractions, you're going to be involved in a very murky discussion in about 10 seconds.
So, I'm glad you reprised that point you made earlier, because I had a thought. You say that you're opposed to free speech as sort of a dominant organizing principle for the academy, but a lot of what you say sounds a lot like what free speech people say. I wonder if what you're really saying is you believe in free speech, you just believe that there are what the lawyers would call the time, place, and manner restrictions that are obviously appropriate in the academy. You can't have classrooms. You would never teach anything if it was a true free speech forum. So there are a lot of time, place, manner restrictions that academies, like any institutions, must have. But principles of free speech like viewpoint neutrality, viewpoint non-discrimination, and such, and sort of free speech maximalism within a framework of reasonable regulation. Is that what you're saying? And you're just calling it inquiry rather than speech?
I would not say that there's no overlap between what I would call the imperatives of academic inquiry and the imperatives of free speech. But I think that overlap is accidental, or should be accidental, rather than designed. If you keep your focus on the nature of the academic task and the constraints that task therefore imposes, which includes certain kinds of freedom and excludes other kinds of freedoms, I think you can come to a reasoned analysis of the situation, which I've been trying to do, and I know others on this panel have been trying to do for many years, and will no doubt continue to try to do.
Any other final comments before I turn it back to Alita?
I'd say the only one other thing I'd say is that I think I agree with a lot of your last point to my discussion, Professor Fish, and I also agree that we should have a place where we can discuss these ideas very freely and fairly, and have this, we're not becoming overly moralized in the classroom. But I think the problem is you have to have these high principles of free speech undergirding that freedom of inquiry, because otherwise I don't see how it doesn't devolve into the situation we have, where some ideas are being suppressed, aren't being discussed. And this may not be a policy way to hold administrators accountable, but I at least highly encourage any other law students or around these places to speak up and say, hey, we really want to have these perspectives heard. I think raising our voices, saying, look, these things need to be discussed, they need to be addressed, we need to have these platforms, is valuable and important. And being silent and seething and, oh, great, I have to go to another webinar panel or do another set of readings outside of class to get the education I need, isn't helping. So I encourage people who are excited about these issues and think it's important to speak up and advocate for themselves at the administrative level and otherwise.
Let me just say that any student who told me that he or she wanted a certain perspective discussed would receive absolutely no hearing from me. The question is not what my students want to have discussed. The question is what I want to have discussed, and that's it.
Well, with that, thank you all for this. I hope I speak for the audience. A wonderful discussion by these just fantastic panelists who are clearly devoted to making our country and our institutions of higher education stronger. So I hope everybody agrees that we deserve the panel. Thanks. Alita, we'll turn it back to you.
Oh.
You need to turn off your mute.
Damn it. Such a rookie mistake. On behalf of the Federalist Society, I want to thank our panelists and moderator for the benefit of their time and expertise today. Thanks very much to the audience for joining and participating in the event and offering up such great questions. We welcome listener feedback by email at info@fedsoc.org. Hope to see many of you next week at NLC. Thanks very much for joining us today. We are adjourned.